Welcome back, dear students. Today we are going to learn the drafting of a gift deed. So first of all, you must understand what is a gift. In common parlance, gift is a sale without consideration. But legally speaking, gift is a transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another called the donee and accepted by or on behalf of the donee. You see, in the matter of gift also, like a contract, there must be an offer and acceptance. Gift must be offered by one party, then it must be accepted by another party. And this acceptance has to be made during the lifetime of the donor and while he is still capable of giving. If the donee dies before acceptance, the gift is void. So acceptance is very important ingredient in accordance with section 122 of Transfer of Property Act 1882. So dear students, while drafting a deed of gift, you must draft one paragraph on the acceptance of the deed, acceptance of the gift, and one paragraph saying that the donor has offered this gift to donee. Now suppose gift is made to several persons and one of them does not accept. Then that gift becomes void as to the interest which would have taken had he accepted. So the portion which is accepted by the other donees is valid, and the portion of gift which is not accepted by a particular donee is void. Now gift, how to do it, how it is affected. For the purposes of making a gift of immovable property, the transfer must be effected by a registered instrument, signed by or on behalf of the donor and attested by at least 2 witnesses. But for the purposes of making a gift of movable property, the transfer may be effected either by a registered instrument or by delivery. For example, if I wish to gift you my pen, I can deliver the pen to you and say it is gift for you because pen is a movable property. Car, scooter, all movable properties can be gifted away either by registered instrument or by delivery. So here the registered instrument is optional if the property is movable. Registration is compulsory if property is immovable. Now, dear students, your client comes to you and requests you for drafting of a gift deed regarding his existing properties and future properties. You must advise him that a gift can only be made of existing property in present time. A gift of future property is void. Suppose I say that in future, whenever I will purchase a Mercedes car, I will gift it to you. And I may not purchase Mercedes car in future. So a gift of future property is void. And when a gift is mixed, a gift comprising of both existing and future properties is void as to future properties and valid to the extent of existing property with the donor. Now, dear students, you must be aware of this factor that when gift is liable to be suspended or revoked. You see, donor and donee may agree that on the happening of any specified event, which does not depend upon the will of the donor, a gift may be suspended or revoked. But a gift which the parties agree that it shall be revocable wholly or in part at the mere will of the donor shall be void wholly or in part as the case may be. So if the gift you are going to draft, the donor says, please write down in the will, in the gift, that this gift shall be revocable at my sweet will. So such a transaction is void. So dear students, a gift may be revoked on all those grounds on which a contract may be rescinded, except for want or failure of consideration. So you have studied the grounds on the basis of which a contract may be rescinded or set aside. On the same grounds, a gift can also be rescinded. Save as aforesaid, a gift cannot be revoked once it is validly made. This is the mandate of section 126 of transfer of property. Then, dear students, there are other categories of gifts also you must know, and one of them is onerous gift. Onerous gift means when you are putting burden on the donee. When a gift is in the form of a single transfer to the same person of several things, of which one is burdened and others are not burdened by an obligation. So donee can take nothing unless he accepts the gift fully. But when a gift is in the form of two or more separate and independent transfers to the same person of several things, the donee is at liberty to accept one of them and refuse others, although the former may be beneficial and later may be onerous, because the items are different, transactions are different. So donee can refuse to accept the onerous gift. Now there is another concept of universal donee and his liability. You see, subject to provisions of onerous gifts, where a gift consists of donor's whole property. I have gifted away my entire property to one of my students, who is the donee. Then that donee student is personally liable for all the debts due and liabilities of the donor at the time of the gift to the extent of the property comprised therein. So this is the legal position of universal donee, that if a person is gifting away his entire property, so the donee has to accept the debts and liabilities of the donor also, but to the extent of what he got in the gift. These rules will not be applicable to deathbed gifts of movable property made by a Mohammedan client. If your client is Mohammedan, then these rules are not applicable to deathbed gifts. And these rules will not affect any provision of Mohammedan law also. Because gift or hiba by a Mohammedan, a hiba is a Urdu word or gift in English. I told you is a transfer of property made immediately and without any exchange by one person to another and accepted on behalf of the latter. Here we are talking about movable property only. And same is true about the immovable also, that a gift or hiba is a transfer of property made immediately and without any exchange, of course, by one person to another and accepted by or on behalf of the latter. Now, who has the capacity to make a gift? If your client is Mohammedan minded, every Mohammedan of sound mind and not a minor may dispose of his entire property by way of gift. And gift may be made even to an heir as opposed to a will. And writing of oral gift is also not necessary under Mohammedan law. If a gift is to be made by a Mohammedan, writing is not essential for the validity of a gift, either of movable or immovable property. Chapter 8 of TP Act, that is section 122 to 129, is not applicable to Mohammedan gifts. Dear students, if your client is Mohammedan, you will draft 3 ingredients in the deed of gift, or of course it can be made orally also. So 3 ingredients are: number 1, a declaration of gift by the donor; second, an acceptance of the gift expressed or implied by or on behalf of the donee; and third, immediate delivery of possession of the subject matter of the gift by the donor to the donee. So far as registration of Mohammedan gift is concerned, gift of immovable property must be registered if it is made in writing. But it will not cure the want of delivery of possession. Delivery of possession has to be made immediately. If it is proved by oral evidence that gift was validly made as required by Mohammedan law, then it is immaterial that the donor had executed a deed of gift, because Mohammedan can make a oral gift. Similarly, Mohammedan can make a gift of undivided share in property also. In Urdu, this undivided share is known as musha. Gift of undivided share of property which is not capable of partition, either movable or immovable, may be made by a Mohammedan. And in Mohammedan law equally, the gift of future property is void. Contingent gift is also void. And if you attach a condition with the gift, your client says, who is a Mohammedan, that I wish to put a condition while writing a gift deed. So when a gift is made, subject to the condition which derogates from the completeness of the grant, the condition is void and gift is valid. And it will take effect as if no condition was attached to it. Meaning thereby, gift with a condition, gift will operate fully, condition is void. Now, dear students, I am putting summary of rules of a gift before you. Gift is a sale without consideration. A gift deed is a legal document that describes voluntary transfer of property from donor to the donee without any exchange of money. Donor must be solvent and should not use this tool for tax evasion and illegal gains. And then a gift deed is a deed in which the consideration is not monetary, but it is made in return for love and affection. Acceptance to the gift deed by the donee is mandatory. A gift deed will be considered invalid if the donee is not willing to accept the gift. Thus, signature of the donee is a must to make the gift compelling on both the parties. So if you are going to draft a gift deed on behalf of your Mohammedan client, signature of both the parties are required. And the donee must accept the gift within the lifetime of the donor. Section 123 of TP Act says that a gift of immovable property cannot pass the title to the donee unless gift is registered in accordance with provisions of Indian Registration Act. Then Attestation by two witnesses is required during registration. The title passes only after the registration. So, dear students, a legally executed and registered gift deed cannot be revoked unless the same is a conditional gift. Once the property has been gifted to the donee, donor cannot subsequently revoke or cancel it. A unilateral cancellation of gift is invalid. However, revocation of gift is allowed on certain grounds under TP Act. So, dear students, with this much background knowledge with us, now we will start the drafting of deed of gift. So, heading will be deed of gift. Operating line is to be drafted like this, that this deed of gift is made on this first day of January 2017 between A son of B, resident of 906 Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP, hereinafter referred to as donor of the one part, and second party is Mr. X son of Y, X son of A, resident of 52 Lajpat Nagar, New Delhi, hereinafter referred to as the donee of the other part. So in the beginning, we have drafted the heading, then date of deed, and name and complete address of donor as well as donee. Now these paragraphs are the history of this gift deed. They begin with the word whereas. Whereas the donor is seized and possessed of the land and premises situated at flat number 906. This is the complete address of the donor, whereas the donor is seized and possessed of the land and premises situated at flat number 906 Designers Park, Sector 62, Noida, Gautam Buddha Nagar, UP, and more particularly described in the schedule hereunder written. And whereas the donee is related to the donor as his son, and whereas the donor desires to grant the said land and premises to the donee as gift in consideration of natural love and affection, as hereinafter mentioned, and whereas the donor desires to grant the said land and premises to the donee as gift in consideration of natural love and affection, and whereas the donee has agreed to accept the gift as is evidenced by his executing these presents, and whereas the market value of the said property is estimated to be rupees 1 crore only. Now the operative part of the deed starts. Now this deed witnesses that the donor, without any monetary consideration and in consideration of natural love and affection, which the donor bears to the donee, do hereby grant and transfer by way of gift the said land and premises situated at flat number 906 Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP, and more particularly described in the schedule hereunder, with all the buildings and structures thereon, and all the things permanently attached thereto, or standing thereon, and all the liberties, privileges, easements, and advantages appurtenant thereto, and all the estate, right, title, and interest, use, inheritance, possession, benefit, claims, and demands, whatsoever of the donor to have and to hold. These are the operative words now. To have and to hold the same unto and to the use of doni. Absolutely. But subject to payment of all taxes, rates, assessments, dues, and duties, now and hereafter chargeable thereon to the government or municipality or other local authorities. So up to the date of the deed of gift, the donor will pay all these taxes, but after the date of gift, when the deed is registered, donee is liable to pay all the taxes and dues from government or municipal authorities. And the donor do hereby covenant with the donor. Now these are the terms and conditions on which the gift is being made. A, that the donor has in himself good right, full power and absolute authority to grant the said flat and other premises hereby granted as gift in the manner aforesaid. B, the donee may at all times hereafter peaceably and quietly enter upon, occupy, possess and enjoy the said piece of land and premises and receive the rents and profits thereof and every part thereof too and for his own use and benefit without any suit, lawful eviction, interruption, claim or demand whatsoever from or by the donor or his heirs or executors, administrators and assigns or any person or persons lawfully claiming to or claimed by, from, under or in trust from for the donor. So all these rights will transfer from donor to the donee. C, third one, that the said flat and premises are free and clear and freely and clearly and absolutely and forever released and discharged or otherwise by the donor and well sufficiently saved, kept harmless and indemnified of and from and against all former and other estates, title, charges and encumbrances whatsoever made, executed, occasioned or suffered by the donor or by any other person or persons lawfully claiming to or claim by or from or under in trust for the donor. And fourth, D clause, and further that the donor and all persons having or lawfully claiming any estate or interest whatsoever to the said land and premises or any part thereof from, under or in trust for the donor or his heirs, executors, administrators and assigns or any of them shall and will from time to time and at all times hereafter at the request and cost of the donee do and execute or cause to be done and executed all such further and other acts, deeds, things, conveyances and assurances in law whatsoever for better and more perfectly assuring the said land and premises and every part thereof unto and to the use of donee in the manner as aforesaid by the donee, his heirs, executors, administrators and assigns or counsel in law shall be reasonably required. Now, dear students, the last part of the gift deed is that two witnesses are required. So last paragraph will begin like this. In witness whereof the donor as well as the donee by way of acceptance of the said gift have put their respective hands on the day and year, on the day, month and year, it should be day, month, and year first herein above written. Now, before the signatures of the donor and donee, you are supposed to write down the schedule of property gifted. And this schedule has to be given in detail, complete detail of the property and how it is bounded and butted from 4 sides in the north, in the south, in the west, and in the east. Then after drafting of schedule of property gifted, signature of the donor are to be taken on this deed. Donor will write down signed and delivered by the donor above named in the presence of 2 witnesses. Then comes the signature of the donee. Donee will also sign in the presence of 2 witnesses. Same witnesses will be there. So this gift deed is to be signed in the presence of 2 witnesses. Witness number 1, his signatures is complete name and address like C, son of D, resident of 53 Lajpat Nagar, New Delhi. And witness number 2, his signatures are to be obtained and his complete address, say E, son of F, resident of 54 Lajpat Nagar, New Delhi. And dear students, when you have added the schedule of property gifted away, you are supposed to attach a geo-tagged photograph of the building which has been gifted away in this gift deed. So I'll mention here geo-tagged photograph. Geo-tagged photograph of the building. Gifted away. This is to be drafted by you, and the latest version is that whenever signatures of donor are obtained, then his photograph is also to be affixed on this deed. Photograph is essential so as to keep his identity intact. And not only this, the photocopy of the Aadhaar card is also to be made part of this gift deed. Similarly, when donee signs this gift deed, then photograph of the donee is to be affixed here as part of the gift deed. And of course, the photocopy of the Aadhaar card of the donee is also to be made part of this deed. And email address and mobile number of both the parties are to be mentioned here so as to nail the identity of the parties. Similarly, dear students, when witness number 1 will sign this deed, his photograph is also required to be appended on this gift deed. So photograph and copy of Aadhaar card of both the parties and both the witnesses. So here, where you have taken the signatures of the donor, you will write down copy of Aadhaar card of donor is to be attached as part of this deed. And similarly, you will mention here that besides copy of the Aadhaar card, email address, and mobile number of the donor. This is now necessary. Thereafter, he will sign it. Similarly, when you obtain the signatures of the donee, for donee also, my dear students, copy of Aadhaar card, then email address and mobile number of donee. These are the requirements, the latest one, which you must take care. Similarly, when you talk about the signature and photograph of witness number 1, for witness number 1 also, the copy of Aadhaar card is required. Copy of Aadhaar card of the witness, so as to nail his identity. Similarly, email address and mobile number is to be mentioned and drafted here. Likewise, when you obtain the signature of witness number 2, you will obtain his photograph as part of this deed. And likewise, the copy of Aadhaar card, email address, and mobile number of witness. And the latest requirement is the geotagged photograph of the property gifted away. So, dear students, this is how we have learned the drafting of a gift deed along with its all ingredients, and we have covered the drafting of gift by your Mohammedan client also, your Hindu client also. So thank you very much, dear students.